Very good. I apologize for there was a technical issue with the connection. So anyway, I'm going live on YouTube and Facebook group. We were talking about how to stop foreclosure, and the discussion started out talking about the parties. Who are the parties? Well, you have the borrower most of the time, um, and that's the person that borrowed uh, the money to buy the home, and then you have the bank. And a lot of times, the bank is either a servicer or the original lender or an assignee, or new bank that bought the loan. And two, we talked about the venue. Where's all this stuff happening? Where's the foreclosure occurring? Is it occurring in court or out of court? And we said a judicial state is where foreclosures take place in the court. In a non-judicial state, the foreclosure process takes place out of court. All right. Um, in a non-judicial state, um, there's no court involvement. Period. Um, unless you take it to court. In a judicial state, there's court. And I was discussing in New York, which is where I practice. New York is a judicial foreclosure state, which means if you're going to foreclose on a home, you're going to have to take the homeowner to court, and you're going to have to win and get a judgment of foreclosure in order to foreclose. In non-judicial states, you don't have to do that. In non-judicial states, for example, Georgia, for example, I used to have a home in Georgia, and the process is you will typically get a default letter from the bank, and this is according to that state's law, whatever your state. But for example, in Georgia, you will get a default letter, which will then turn into the bank or foreclosure bank would do advertisements for 4 weeks in the legal Oregon, which is the paper in that particular county. And then after that's done, the first Tuesday of the month, there will be a foreclosure sale at the courthouse steps. That's all you have to do in non-foreclosure states. Very swift process with no court involvement. That's a bad thing, I think, because there's no checks and balances. Um, easy for it's easy for consumers to get railroaded in that process. In judicial states, you have judge involvement, you have court involvement. New York, for example, New Jersey as well. But many states have that, Florida. But in New York, the bank would need to, would typically accelerate, do an acceleration letter, which is a letter saying after default, you've defaulted, the loan is due and payable due to an acceleration clause in the loan paperwork. And then that foreclosing bank or servicer, their lawyer will draft a complaint, list pending, summons, file it. They'll get an index number, which is just a case number in the court. And then once they get that, they will serve the homeowner. All that stuff has to take place, okay? And then once the homeowner is served, then that homeowner has 20 days or 30 days, depending on where they're served, to answer that lawsuit. All right. So, all right. So here we go. We have the framework. We have the parties. We know the venue. If you're in a judicial state, the venue is the court. If you're in a non-judicial state, the venue is um, the it is out of court. It's just some letters. It's mail. You mail things. Hi, Karma. Foreclosure should be illegal unless the laws are changed. Yeah. Well, um, let's talk. We're going to talk about that. Most of the foreclosure that takes place is illegal. Okay. So most foreclosure is illegal. And that's meaning a lot of the entities that are foreclosing should not legally be doing so. So, Karma, that's a good point. I would agree with you. Um, uh, and also add on the fact that I think that more foreclosure should be done judicially in states that are non-judicial. It's just too, it leaves too much room for error by letting companies just foreclose on people by sending a letter and advertising. It's a very faulty process in these non-judicial states. It limits your options, and so we're going to talk about how to use those options. So it's not going to be illegal, so you're going to sort of have to work with getting the knowledge to know how to deal with it as it currently is. I have a lot of wishes and things, but we're going to have to be realistic, and we're going to have all the reality checks. And I'm going to give you some of those reality checks and talk about really all the big issues in this video. All right. And so Karma has more questions, and I'm going to take some questions. I'm just laying a framework now. So in a judicial state, how to stop foreclosure. In a judicial state, I would say the top way to stop foreclosure, I'll give you a few ways. One is to hire a foreclosure defense lawyer. Okay, that's a good method. Two is to answer the lawsuit. Once you answer the lawsuit, they can't foreclose on you. Now you're in litigation. You're going to have the opportunity to do discovery. You're going to have an opportunity to try to dismiss the case. Now, if you're going to dismiss the case, most of the time, I recommend moving to dismiss the case before answering. Okay, that's the best posture, I think. If depending on the case, it depends on the case whether or not you can move to dismiss it. But if there are grounds to move to dismiss a case, then I think you should do that. A lot of people skip that step, but if you evaluate a case, if the paperwork is not proper, what I mean by that, if the note is not negotiated to who's foreclosing to you properly, if the mortgage is not properly assigned, all these things have to be done. If they're not done, that case can be dismissed. Is it beyond the statute of limitations? Like in New York, if they accelerated the loan 7 years ago, then guess what? They're beyond the statute of limitations. They can't enforce the mortgage after 6 years. So you have to really evaluate all those things. Unfortunately, this information is great, but if it's not implemented procedurally correct, you may not be able to do anything with it. So if you answer the complaint and you don't mention the affirmative defense of statute of limitation, well, guess what? That's waived. You've waived that defense. Or if you answer the complaint and forget or don't know what the statute of limitations is in your state and don't assert that defense, it's waived. And so now you have to deal with fighting a bank that, had you known what a proper defense would be, you could have implemented it. You may have the opportunity to amend to include that defense. So, all of this stuff, I'm actually working on a book. I've been working on it for a while. It's called 101 Foreclosure Defenses. A lot of people think it's only a handful. I'm going to write a book that's going to give you 101 defenses to foreclosure. All right. So I'm going to try to hurry up on that, but there are many defenses. And when it comes to affirmative defenses, it's important to understand that if they are not asserted or pled in your answer, they can be waived. So some are not waived, but many of the ones that are very important, like statute of limitations and others, can be waived. So I would say, outside of getting a good foreclosure defense lawyer, just answering the complaint is a great way to stop foreclosure. Now, you're not going to default. Now, when you answer the complaint, you have to answer the complaint timely. So people get served lawsuits. People are busy working. So in New York, you only have 20 days to answer this lawsuit if you're served within New York. Say if you're at home in New York and you're served, you only have 20 days. So if you take 2 weeks to get help, and then another week to try to figure out what help you're going to go with, and you're 30 days later, you've defaulted at that point. So as stressful as foreclosure is, you don't have much time to deal with it. So people really need to take action if they are ever served. Now, if you are in a non-judicial state, like we talked about, there's no court, you're going to get a letter saying, hey, you're in default. We're accelerating your loan. We're going to foreclose on you. If you have any questions, call this number. Now, in those states, how do you stop foreclosure? Well, first of all, this letter is really a letter. You'll notice it has language in it like a debt collection letter. All right. So if you go to 15 USC 1692 G B, section B. So it's 15 USC section 1692 G. And then look at section A and B under that. You'll see that language from that federal law in that letter. And basically, section 1692 GB gives you the right to request verification of that debt. Now, when they get that verification request, they actually have to stop collection until they verify the debt. They'll typically do that very quickly so that they can proceed in the foreclosure process. But you have to do that. You have to seek verification of that debt, which will include the information regarding the lender. You can ask for several things, and I recommend you do so, which will include the note, all negotiations, all assignments of the note and the mortgage. But that's something you should do right away. You only have 30 days to do that. And in addition to that, typically you may only have 30 days in general before the properties before the foreclosure steps. Now, if you happen to do a verification letter and they come back and they can't satisfactorily show you the chain of the note and the mortgage to show that who's saying they're going to foreclose and you should foreclose, you may have an opportunity there to negotiate a reinstatement of the note of that loan and things like that. You may have that opportunity, but you have to do this fast and early. If that does not work, typically you can ask for a reinstatement letter. A reinstatement letter is, well, how much does the bank want to get this loan back performing, current, and out of foreclosure? All right. If you do that and enter into a written agreement of reinstatement, then that could stop your foreclosure. However, some people may be so many months behind that they may not have $15,000. If you have a $1,500 mortgage, you miss 10 months, well, they may want $15,000 plus some late fees. Well, sometimes you can negotiate the late fees and all this stuff out if you can provide a lump sum reinstatement. So reinstatement sometimes is an option for people. Now, if you're going to do any of these methods, everything needs to be in writing. So if you're going to do a reinstatement, you want to get a reinstatement in writing. If you negotiate a number of how much you're going to pay to reinstate it and get it back performing, you want that in writing. More so, you want it in writing that foreclosure is canceled, it would be delayed, etc. Shannon says, in Florida, a thief could pick up a note on the floor and photocopy and endorse with no intervening assignments whatsoever and get the judgment. That's correct. And in fact, a lot of the assignments or endorsements, you would, for example, when dealing with foreclosure, you're dealing with two things. You're dealing with a note, which is a negotiable instrument, like a check. It's a promise to pay. You endorse those to get to the next person. Just like if you have a check from work. If you're Bob and want to give your check to Bill, you would endorse it on the back. And if you endorse your name, blank endorsement, you can give it to Bob. But if he drops it on the floor, anyone that picks it up can do whatever with it. All right. And so that's what he's saying with a thief. You can actually, if the note to your home is endorsed by ABC Bank in blank, meaning it's not payable to the order of someone else specifically, they could lose it. And whoever picks it up, if they could steal it, it's whoever's note now to catch, to enforce. All right, so you have notes. I don't want to make it too complicated, but you have notes and you have mortgages. Notes, negotiable instrument. Mortgage is a contract. It's a contract to enforce the obligation of the note. So you negotiate or endorse notes, and mortgages, they are assigned, but they need to be together with the same person. So, if the person that owns the note or the debt if they don't have the mortgage, then they can't enforce default on this note by taking the collateral home that's promised by the mortgage contract. So, I don't want to get too deep into it, but yeah, it's very, very particular, and it is under the UCC laws on how you can properly negotiate. For example, notes, you negotiate a note like a check. You have to sign, if it's payable to the order of Wells Fargo, or Wells Fargo can sign on the back, and an authorized person can sign on the front or back of that note to negotiate to the next person. All right. And if they negotiate it to a particular bank and say pay to the order of, then only that person that's the payee is the person that owns that debt. The mortgage, which secures that debt, needs to be assigned contractually to the next person. Now, a negotiation of the note, the bank, the payee would need to actually sign that note. If they don't actually sign that note, they have to do an allonge. And allonge is a piece of paper that has to be attached to the note and then signed. And so if you have situations where you have a note and you have an allonge, you don't see any staple marks or anything, that could be an unlawful allonge, meaning if that allonge, which is like an endorsement on another piece of paper that's not the note, is not attached to that note, then it's not valid. So a lot of these, like I say, a lot of these issues come up. These are one of the 101 ways you can defend yourself against a foreclosure. So in Florida, with processes, they are not held to any of them. No, he doesn't. Let me see. Sean is saying, no, he doesn't. Well, maybe like all these laws he's telling us to look at, they're not held to any of them. Yeah. So, so I think Sean is referring to there are a lot of legal requirements that banks have to follow. I was just telling you about allonges. An allonge is only effective if it's attached to the note. So if I have, if this is the note, and this note is in Colorado, and this person's in Florida signing an allonge, well, if it's not attached to the original note, that's an invalid allonge. To be able to figure that out, you're going to have to do a lot of discovery. You're going to have to depose who signed that note. All right. And as Sean is saying, a lot of these banks are getting away with fraud because they're not being held to that law. A couple of reasons for that. One, many times you have a default issue with respect to the lawsuit. So a lot of times the homeowners find themselves begging to get to court to defend themselves. Two, when a homeowner can defend themselves, they may not know all the particulars of the law or know of the discovery process. And this can go for lawyers too. Like if you get a bankruptcy lawyer that is really just a bankruptcy lawyer that does not understand negotiable instruments, mortgage law, trust law, then they may not do an adversary proceeding to challenge this stuff. Okay, we're going to get to bankruptcy. So a lot of you have a problem with bankruptcy lawyers because, yeah, they'll get you to bankruptcy, but you have this fraudulent lender trying to say you owe them and they don't, and you may not be able to get that particular lawyer to do an adversary proceeding to deal with that matter. So you're going to really have to interview the lawyers to figure out you have someone that understands. And I know in Florida they've had a lot. There's been a lot of issues with people taking advantage of homeowners, and it's just really tough for consumers out there. I've been through it, I didn't have a lawyer, but I experienced foreclosure before I went to law school. I wish I had a lawyer. I wish I would have had, someone telling me some of these options then. It probably would have turned out differently. But the thing is, the house lost so much value. shoot, uh, almost $500,000 in value because it was at the real estate tank. So, it's sort of fine now. But again, all of these things matter. And the frustration is the courts are not enforcing these laws because of default, because of inexperienced counsel. When you do have experienced counsel that implements these things, well, if you have a bad judge making a bad decision, then the law won't be enforced unless you appeal it. So Sean is correct. There's a lot of laws, not too many. You have the UCC, you have state law. I mean, it's a few laws, but it's a lot of things in those laws that need to be used in each of these cases. So so it can get very frustrating, and also, if you haven't noticed, it can be very expensive. So a lot of people really may not be able to get the expert help they need because it would be very, very difficult to find a consumer lawyer that's going to perform all these things and not break the bank. So I would say a third way to prevent foreclosure is to really save your money. And one second. Once I get some more water. All right, thanks. In most instances, people that are facing foreclosure may not have been in payment of their loan for many months, years. It is very, very, very important to set aside that money. If you have dealt with a life circumstance that sucked all your money out, that's understandable. But understand, unless you're representing yourself, that circumstance cannot be converted to capital. So a reality check is if you have $0, you may not be able to get legal help. And I'm not here to advertise necessarily my help. I'm not, I'm limited to New York. So this is a national video that can apply in any state, but I'm just giving some reality check. I don't, you can use me or not. I'm not charging for this information, but if you are facing foreclosure, about to face it, and sort of getting ready for it, save your money. And if you don't have any money, that will hurt you. But again, you still can try to bring yourself up to speed, put together resources, get with someone, and get the help you need. But I'm here to tell you, like Sean was saying, it's a lot of laws. It's a lot of laws that can help you. And using those laws correctly is one thing. And getting the court to do the right thing is another. And if the court doesn't do the right thing, there's some checks and balances there. So again, how to stop foreclosure. One, get a lawyer that does foreclosure defense, that knows what they're talking about and doing. And you all surely have done enough research to really be able to interview a lawyer and know if they know what they're talking about. So make sure they know what they're talking about. Two, answer the lawsuit. If you're in a judicial state, answer the lawsuit. If you're in a non-judicial state, send what I call a 1692 GB letter. Get verification of that debt. I also recommend you do a qualified written request in conjunction with that 1692 GB letter to get all the documents you need to be able to defend yourself in a non-judicial foreclosure. You need to do that within 30 days of that attorney writing you in a non-judicial state. All right. You can also do this in a judicial state, but in a judicial state, it will all be through the court. So if you serve paperwork, you're in the court process. But if you're in a judicial state and you're just served an acceleration, well, that's your opportunity to do a 1692 GB verification letter, and also if you haven't done so already, QWR. QWR stands for Qualified Written Request under RESPA. Those have to be responded to under the law, or else that's a violation of the law itself. And so, those are the top ways to prevent a foreclosure. Get a lawyer, answer the lawsuit, send a verification letter. Okay. I guess I'm gonna call the fourth method. You have to really save your money. It's very important. You're going to need some financial resources in place, because what I've determined is, unless you really brought yourself up to speed and pretty much taught yourself the law and maybe been to some conferences and have, a lot of material, you're really going to need some expert help. Okay. Some of the pro se groups and things like that, a lot of people have been taking advantage of it. Again, that's unfortunate, but at some point you're going to have to seek out expert help. The unfortunate part about that is some of that help may be expensive. Some of that help may not. There are lawyers out there. You can go to consumeradvocates.org. You have some lawyers that can evaluate your case to see if there's a violation of the federal laws. If there's a violation of any of the federal laws, they may take your case on contingency. So interview lawyers and see which one can evaluate your case. If you have documents, if you do a QWR early on, you may be able to present them with documentation to show that there's a violation. That violation may be by the attorneys trying to collect on that loan, maybe by the servicer. So interview a lot of lawyers, but save your money. Save your money. If you have a $1,500 a month mortgage payment and you stop paying because you got sick, someone had surgery, someone died, well, once you're back in a position to pay, well, first of all, you should really try to negotiate getting a reinstatement of that loan. But if for some reason that wasn't done, save that money, because at some point that lender they're not going to forget about you, but at some point they are going to come to you to foreclose, and you want to be in a position to say, hey, look, let's reinstate this thing, et cetera, et cetera. All right. I see it too many times. People get very comfortable with making no payments. They use that money for something else. And then when it's time to reinstate, they want to, say, well, all kind of excuses. But you have to take responsibility for the financial part of it. If it's a bad loan, okay, great. You can litigate that, but you're going to spend tens of thousands of dollars on a quiet title. You can litigate that. Most of these loans are not negotiated properly. I'll say that again. Most of these loans are not negotiated properly, which means who's trying to foreclose on you is likely not the proper entity. So a lot of people hear me say, well, you can settle by reinstatement, loan modification, things like that. Well, that is true. You can, and that could solve it. It helps you in that now you don't have to worry about getting foreclosed, and it helps that servicer because their paperwork really isn't all that great. So they can make it solid, and you could have peace of mind. You could also defend against a foreclosure or do a quiet title action to determine that who's trying to foreclose, and you can't. But guess what? That costs. So it's really a business decision on what you're in a position to do. You may be in a position to reinstate, and to reinstate, you may have to sign a loan modification agreement with this new servicer lender whose paperwork wasn't all that great. But you may not have the money to go through the loan process of a quiet title action, but the bank does. They will go through that whole action with you until the end, and their money will not run out, but yours may. So those are some options. All right. Now, in non-judicial states, you can't reinstate for whatever reason. The money may not be there, which is a typical problem. You may not have all that money to reinstate it. If you don't, negotiate. Say, look, I don't have this much to reinstate. I have this much to reinstate. We can spread the payments out over a certain period of time. Negotiate. But the negotiation has to be fast. They're not going to, unless If the negotiations are slow, say, look, can you cancel the foreclosure or delay it to the next month while we negotiate this? Get it in writing. Okay, if you can get that in writing, that's going to stop the foreclosure. Everything needs to be in writing. If they say they can't put it in writing, that means they're not going to do it. They're not going to cancel the foreclosure. Do not trust any of these lawyers or banks. If you're trying to negotiate with the bank and it looks like you're getting somewhere, no matter what state you're in, if you serve a lawsuit, answer it, or if you're in a non-judicial state and you're negotiation and you get served a letter by a lawyer saying, hey, we're going to foreclose, believe it. Do not trust that they are negotiating with you in good faith and won't foreclose. They will foreclose. So if you don't have a foreclosure cancellation letter or a foreclosure delay letter saying they'll delay it or suspend it until next month, they're not going to do it. All right. So do not trust the bank's lawyers. Put everything in writing. If you work out something, if you work out a reinstatement, get it in writing before you make the payment. After you make the payment, do it in a way where you have proof of that payment. All right. And you're going to be okay. All else fails, if you're in a non-judicial state and you're unable to work out a reinstatement, you do a 1692 GB letter in QWR. They come back. With those responses, and they're going to move forward in foreclosure. And you have no other option. You don't have enough money to reinstate it. You can't negotiate a lower reinstatement. You can't negotiate a modification. Well, okay, you may have to look at bankruptcy. Specifically, you may have to look at Chapter 13 bankruptcy. Now, again, Chapter 13 bankruptcy, what that does is, say if you're $15,000 behind, well, that Chapter 13 will take those pre-petition arrears and you'll have the opportunity to pay that out over time. Those future payments you're going to have to pay too. So bankruptcy does not stop future payments. So if your payment is $1,500, once you file bankruptcy, Chapter 13, for example, well, those payments that you are in arrears will be dealt with in the bankruptcy, but the payments moving forward, you have to pay it every month. And if you don't, what they'll do, you'll hear the bank will file for relief of motion of the stay so they can foreclose based on the post-petition default of not making payments. All right. So bankruptcy does not just magically stops everything, but quickly thereafter, you're responsible for making future payments and you're going to quickly be put into a plan on making past payments. So you're going to be making sort of double payments. You're making future payments and back payments spread out over time. I think, you can pretty much, you may be able to spread out up to 60 months. So that's how that works. Now that will stop foreclosure due to the automatic stay. But again, you have to be compliant with future payments and compliant with all the bankruptcy rules. And so it's highly recommended for the bankruptcy to get a bankruptcy lawyer. I saw someone write, well, you can just fill out some forms and do bankruptcy and go to, do an online course and file a bankruptcy. Yes, you can. But bankruptcy moves very quickly. A lot of rules involved, a lot of requirements. If you don't miss the requirements, the court will dismiss your case. And when that case is dismissed, so is the stay. The stay is removed and boom, you can be foreclosed. So again, good to have expert help, a good bankruptcy lawyer. Ideally, it's great to get one that has some experience in adversary proceedings, because if you think there's an issue with your loan, you may be able to use that to your advantage through adversary proceeding, make them prove that they should be foreclosing on you, and you may be able to get a modification or some type of deal worked out. And I only say modification because to really get this loan to go away, you're going to have to go through a quiet title action. That's going to take a lot of resources and time, and most people are not up for that. They would rather do a modification, which may include a principal reduction, than go through the whole process of clearing out that loan altogether. Those are your options. So let's see what kind of questions we had. We had Karma. In Florida, it's not even a bank. The court allows a third-party debt collector to come take your home. Yeah, I mean, look, you don't have to be a bank to foreclose. Anyone can buy these debts, allegedly. You could go buy a note, get an assignment from a mortgage. So yeah, it doesn't have to be a bank at all. Most of us can't afford a lawyer. Karma, yeah, I spoke about that. Most people can't afford a lawyer. That's why I spoke about some non-lawyer options, like taking the money you have put together to get that loan reinstated, communicating with that bank's lawyer and saying, hey, I want to reinstate the loan, give me a reinstatement letter. They're going to ask for $15,000 if you got $15,000 back payments. I don't have $15,000. Can you do it for $4,000 this month, for next month, and 1,000 next month, or something like that? That's 12 or 3 last month. Okay, so that's just a fact. If you have $0 to your name, if you have $100 to your name, and you're facing foreclosure, you're likely just going to lose your home. That's the fact of life. There's no way to reinstate the loan if you can't reinstate it or make payments on that loan, the house. And look, I've been there. There is life after foreclosure. Okay, so if you don't have it, you don't have it. Promise you, life does not end. Promise you. Okay, but most of you, if you can't afford the lawyer, a lot of you that are saying they can't afford the lawyer, you may not be able to afford the payment if they were to reinstate you. Okay, if that's the case, there is life after foreclosure. If you ran into bad times, times are better now, you have money to reinstate, go for it. Times are better now, you have time to retain a lawyer for it, even better. Times are still bad, you don't have it, you're not going to have it anytime soon, you're still sick, husband died, wife died, you may want, answer the complaint, buy yourself time, try to find reasonable rental housing. Okay, everybody's not gonna be able to save their home. I've been through it. So everybody's not gonna be able to save your home, their home. Okay, don't kill yourself. There is life after foreclosure. You can't afford a lawyer, you can't reinstate. Do not harm yourself. There is life after foreclosure. It's just a home, it's just a loan. I promise you. I promise you. And some of you out there thinking about doing something bad, thinking about burning your house down, don't do it. Don't do it. Don't do it. So understand what your options are. And guess what? Your option may be buying more time, transitioning into something that you can afford. Okay? So understand, everybody's not going to be able to save their home. Been there, lost a home. There's life after that. Okay. So that's for karma, and I say that with love. Everybody can't utilize these options. Now, personally, after my home foreclosed, I ended up going to law school, learning about this whole process. I've since, bought a home, sold a home. I help people, and like videos like this, I try to impart that knowledge. I'm not charging for this. I'm going to do a book, 101 foreclosure defenses people can use. I'm going to put stuff out, real affordable stuff. Teach, give back and teach people. But again, be aware, if you're dealing with a non-lawyer. Now, if I went through this and I wasn't a lawyer and I'm just giving you some tips, I wish I would have done this, you have to watch out for that advice, because if you're not really, if you haven't gone through the entire process successfully, or legally litigated these matters, or dealt with the banks, the courts, you really have to be careful with those people advising you of that. And again, as I said in the beginning of the video, people that survived foreclosure without a lawyer or did something, that's their case. Your case is not their case. You can have the same bank. It could be Ocwen, Wells Fargo, whoever. JP Morgan Chase Bank, but each case is different. So if one person did this and saved their home, they could package that into a $200 product, sell it to you. Doesn't mean it's going to work for you. All right. It might, but it doesn't mean it's going to work for you. Let's see. Any other questions? I'm going to wrap this up. We've spent, a little less than an hour. So how to stop foreclosure. Get a lawyer. Get a foreclosure defense lawyer. 2, answer the lawsuit if you're in a judicial state. If you're not in a judicial state, you're going to get an acceleration letter. You're going to get a default letter. Answer that with a QWR and 1692 GB letter. 1692, I'm talking about 15 USC 1692 GB. You can look at that law. QWR, I'm talking about the rest of the law, qualified written request. Answer it with that. 3, try to reinstate that loan. A lot of you have seen information about reinstatement where a lot of these lenders they don't have the paperwork together. So you feel bad about reinstating something that's not good, but the option other than reinstatement would be to do a quiet title action. You have to hire a lawyer. That can cost tens of thousands of dollars to do a quiet title action to completion. So a lot of people don't want to spend that money. So reinstatement typically will include some negotiation, a modification, may reduce the principal. If you're upside down, consider reducing the principal, make the payment affordable. So it's a win-win for both sides, but it's not the most beneficial result for either side because, this lender or servicer may not even have their stuff together. You're going to get it together when you do this modification, but you're going to get that from over your head and you get an affordable payment. If you can't afford the reinstatement as they propose, negotiate a better deal. Negotiate. You must do it fast. Get everything in writing. If you reinstate, get in writing that it's reinstated, that is going to be reinstated once you pay this amount. Once you pay that amount, make sure all the paperwork reflects it's reinstated and the foreclosure is canceled. Everything should be in writing. Anything you agree to should be in writing. You have to do it fast. All else fails. Well, if you're in a judicial state, be sure to move to dismiss if there's grounds to do so. Otherwise, answer the lawsuit. Conduct discovery, extensive discovery. A lot of times, these people foreclose and don't have the right to do so. You can only find it out by discovery, paper discovery, written discovery, and depositions. All right. Also, save your money. If you have a $1,500 a month payment, you should be saving at least that much, so that when the time comes for you to reinstate, you're in a position to do so, or do so at a discount to negotiate. You can't expect to save your home without any money. You just can't do it. Okay, can't do it. Can't do it. Well, I'm pro se. I'm going to do. Well, guess what? Unless you're going to do a quiet title action to extinguish that obligation, if you're going to answer that lawsuit, the court's not going to just throw it out. You're going to have to go through a full-fledged quiet title. That's going to have to be through counterclaim or separate action, depending on what stage you're at. You're going to have some money at some point in this process. So if you don't have any money, consider your options to delay and transition to something you can afford. Just no way around it, okay? No way around it. And again, been there. There is life after foreclosure. And in fact, your life can be better after foreclosure, okay? I'm sure someone's going to take that sound bite and quote that and make it a negative. But trust me, my life is way better now than before. There's life after foreclosure, period. And this is not to disparage anyone that may not have money. Look, life happens, but do not, and I repeat, do not hurt yourself. Do not hurt someone else. Do not destroy property, because if you burn down your own property and you have insurance, you can't file a claim. That would be insurance fraud. So don't destroy property. your own property. If it forecloses, you know, it's not worth it. Okay. Know your options. Look at this video over and over. Contact a foreclosure lawyer, discuss your options. Contact bankruptcy lawyers, discuss your options. Some of the options we discussed finally were bankruptcy, Chapter 13. Keep in mind, Chapter 13 takes your arrearage payments that you missed, spreads it out over time to repay it. But when you file a bankruptcy, Chapter 13, you're still responsible for payments after that filing. So you can't file Chapter 13 and not make the next month payment. They're going to move for a lift of the stay. Okay. So let's see, any other questions? All right. Well, look, hopefully that was helpful. Like I said, it was just a handful of things I gave you, but that handful of things is like 101 ways to do it. I gave you a handful of options on how to stop foreclosure. If this was helpful, like it, subscribe to my page. I'm going to give you more information, as much as I can. Just to sort of educate you. Like I said, someone was writing, we need to educate ourselves on this stuff. Well, that's exactly the purpose of this video. To educate you on your options. If you have any feedback, give it. But there's going to be people who's going to have negative feedback. Okay, that's fine. People are going to have negative feedback. Like I said, a lot of people are taking advantage of. And but negative feedback, it's not going to help you. Don't do anything negative. There's hope. So look at the video, take it at full value from start to finish, and that should help you. That should help you. I'll come back, look at comments every now and then, but I hope this was helpful. For those of you that are going through this process already, and it's going the wrong way, look, I'm praying for you to make it through this, because it's very stressful. A lot of you may have had your home 10, 15, 20 years, and it may not be going your way, but I'm here to tell you, there is life after foreclosure. If any of these options don't work for you or have not worked for you, again, there is life after foreclosure. And a lot of times, these options, you may hear them and say, well, Brian, this won't work for me. That's true, because if you're in default of the lawsuit, or if it's post foreclosure, it's very difficult and very expensive to go back and correct some of that. And if you try to do it, a lot of times you may be limited to a financial compensation for damages, and to get that, you're going to have to go through a whole legal proceeding. So, like I was saying, what works for someone won't work for everyone. So everyone really has to look at their case specifically with expert help to be able to determine what's best. But what I talked about today really applies broadly, and it can, hopefully give you enough education to be able to interview lawyers, to be able to deal with banks, lawyers, to negotiate a reinstatement, to get everything in writing, all that stuff. Simple advice, but very, very, very important. Okay. Thank everyone for tuning in, and I hope you have a great day today.